Welcome back to Module 4, The Philosophy of Gathering Concrete Evidence. My name is David Tan. In this module, we will examine the fundamental principle that the purpose of gathering evidence is not to validate a preconceived belief or to assign blame to any individual. Rather, the objective of an investigation is to establish findings based on evidence, with facts guiding the investigative process and the conclusions reached. Every unsafe act, unsafe condition, or organisational failure leaves behind evidence. It is the responsibility of the investigator to identify, preserve, collect, analyse, and objectively interpret that evidence. Findings and conclusions should be supported by credible, verifiable facts and logical analysis, rather than assumptions, personal opinions, speculation, or the benefit of hindsight. By adopting an evidence-based approach, investigators can ensure that their findings are fair, impartial, and capable of withstanding objective scrutiny. 4.1 Investigation into Unsafe Practices. An effective investigator into unsafe practices continually asks, what evidence supports this conclusion? What evidence contradicts this conclusion? What evidence is still missing? Is there another explanation that better fits all the available evidence? This immediately aligns the chapter with the learning objective. 4.2 Obtain information and gather evidence. As discussed in Module 2, the collection of evidence is a critical and often sensitive aspect of any investigation, as unsafe workplace practices invariably leave behind indicators of the events that transpired. Such evidence may take the form of physical items, documentary materials, electronic records, environmental conditions, or observations provided by witnesses. The integrity and effectiveness of an investigation depend not on assumptions, speculation, or subjective opinion, but on the investigator's ability to identify, preserve, collect, and analyze evidence that accurately reflects the sequence of events. For the purposes of investigation, evidence generally falls into three principal categories: documentary evidence, physical evidence, exhibits, and witness evidence. Each category serves a distinct evidential function and, when considered collectively, provides a reliable basis for establishing the facts and determining the circumstances surrounding the incident. 4.3 Principles of an evidence-based investigation. Before discussing documents, exhibits and witnesses, introduce several principles. Principle 1: Evidence comes before conclusions. Investigators should resist forming conclusions immediately after arriving at the scene of unsafe practices. Instead of asking, who caused this incident? Ask, what evidence tells us what happened? This helps minimize confirmation bias and premature judgment. Principle 2: Every piece of evidence tells only part of the story. No single piece of evidence should normally be relied upon in isolation. For example, a damaged machine shows what failed, maintenance records show whether the failure was foreseeable, training records show worker competency, witness statements explain human actions, CCTV confirms exhibit evidences. Only when these pieces are combined can investigators reconstruct events accurately. Principle 3: Evidence should be corroborated. Good investigations seek multiple independent sources confirming the same fact. Example: a witness says the emergency stop button failed. This should be verified by maintenance records, inspection reports, physical examination, testing by competent personnel. The more independent evidence supports a finding, the greater confidence investigators can have. Principle 4: Absence of evidence is not evidence of absence. Sometimes evidence has been destroyed, removed, or overlooked. Investigators should distinguish between there is no evidence and evidence has not yet been found. 4.4 Documents. Documentary evidence is among the most significant forms of evidence in legal and investigative proceedings. It encompasses any form of documented material, including but not limited to employment contracts, inspectors' notes, product labels, computer records, spreadsheets, and training records. As a general principle, documentary evidence should be authenticated or identified by the individual with the most direct knowledge of the document and its contents. Such evidence plays a critical role in establishing the facts and circumstances surrounding an incident, including identifying the underlying cause or causes of an unsafe practice. Instead of simply listing documents, explain why documents matter. For example, documentary evidence frequently provides the organizational context and historical background underpinning an unsafe practice. Whereas exhibit evidence tends to establish what occurred, documentary evidence often elucidates the reasons and circumstances that gave rise to the conditions existing prior to the occurrence of the unsafe practices. Examples include risk assessments, safe work procedures, inspection reports, maintenance records, permits to work, training records, competency records, work schedules, overtime records, procurement records, audit reports, electronic access logs, emails relating to maintenance or safety concerns. 4.5 Exhibits. Exhibit evidence, also referred to as real evidence, comprises tangible objects that are relevant to an occupational health and safety investigation or legal proceeding. Such evidence may include machinery, tools, equipment, personal protective equipment, PPE, damaged components, hazardous substances, safety devices, warning signs, or any other physical item associated with the incident. Where relevant and admissible, these exhibits may be tendered as evidence to assist in establishing the circumstances of the incident, identifying hazards and contributing factors, assessing compliance with applicable safety requirements, and determining the cause or causes of the incident. For example, physical exhibits may include damaged equipment, defective PPE, broken tools, failed components, chemical samples, debris, warning signs, machine guards, environmental measurements. Recorded exhibits may include photographs, drone imagery, digital recordings. Physical and recorded exhibits are generally regarded as highly reliable forms of evidence because they exist independently of human recollection and are less susceptible to inaccuracies associated with memory. However, investigators have a duty to ensure that all exhibits are properly preserved, identified, labeled, documented through photographs where appropriate, and safeguarded against damage, alteration, or contamination. In the modern investigative environment, the increasing use of artificial intelligence also presents challenges in verifying the authenticity, origin, and integrity of digital exhibits, requiring careful assessment of their reliability and evidentiary value. 4.6 Conversion of verbal evidence into documentary evidence, including statements from injured persons and witnesses. A significant source of evidence in investigations concerning unsafe practices is the information obtained from persons having knowledge of the relevant events. Statements provided by witnesses who possess direct knowledge of the circumstances surrounding an unsafe practice may constitute direct evidence and, subject to the applicable rules of evidence, may be admissible in enforcement or other legal proceedings. Where witnesses are interviewed during the course of an investigation, investigators should, wherever reasonably practicable, undertake a thorough examination of the witness's account to assess the accuracy, reliability, consistency, and relevance of the information provided. A fundamental principle of the law of evidence is that a witness should ordinarily give evidence only of facts within their own personal knowledge, derived from what they personally observed, heard, or experienced. Evidence based upon information received from another person, rather than the witness's own observations, is generally characterized as hearsay or indirect evidence and may be subject to restrictions on admissibility. The distinction between direct evidence, hearsay evidence, admissions, and opinion evidence may be illustrated as follows. Direct, first-hand, evidence. Direct evidence consists of evidence derived from a witness's own observations or personal experience. Such evidence is generally regarded as the most reliable form of factual evidence because it is based upon matters personally perceived by the witness. For example, I observed that the machine was operating without a safety guard fitted. As the statement is based upon the witness's own observation, it constitutes direct evidence and may, subject to the applicable rules of evidence, be admissible in legal proceedings. Hearsay, indirect, evidence. Hearsay evidence consists of statements based upon information communicated by another person rather than upon the witness's own knowledge. For example, an employee informed me that the machine did not have a safety guard fitted. In this example, The witness is merely repeating information received from another person and is not giving evidence of matters personally observed. Unless an applicable exception to the hearsay rule applies, such evidence may have limited evidentiary value and ordinarily requires corroboration by independent evidence before it can be relied upon. Admissions. An admission is a statement made by a person acknowledging facts that may be contrary to their own interests or legal position. Subject to the applicable rules of evidence, admissions made by a party to proceedings may be admissible as evidence. For example, the employer informed me that they instructed the maintenance personnel not to install the safety guard on the machine. Such a statement may constitute an admission by the employer concerning the instructions given. However, the admission alone does not establish that the machine was in fact operating without a safety guard at the relevant time. Independent evidence, such as photographs, inspection records, or witness observations, may still be required to establish the existence of the unsafe condition. General opinion. As a general rule, witnesses should confine their evidence to factual matters within their own personal knowledge and should avoid expressing opinions, assumptions, beliefs, or conclusions. Opinion evidence is generally inadmissible unless it falls within a recognized exception to the opinion rule. One of the principal exceptions concerns expert opinion evidence. A suitably qualified expert may express opinions within their recognized field of expertise where those opinions are based upon specialized knowledge acquired through education, training, study, or experience. Depending upon the issues under consideration, expert witnesses may include engineers, medical practitioners, occupational health and safety professionals, technical specialists, or other persons possessing recognized expertise in a particular discipline. Where a witness's account is likely to be disputed or contradicted by other evidence obtained during the investigation, the investigator should, wherever reasonably practicable, afford the witness an opportunity to respond to the conflicting information during the interview. Doing so promotes procedural fairness, enables inconsistencies to be explored and clarified, and assists in assessing the credibility, reliability, and probative value of the evidence ultimately relied upon. Expert opinion. Expert opinion evidence may be required where an investigation involves technical, scientific, engineering, medical, or other specialized issues that cannot be adequately assessed by the investigator or other persons involved in the investigation. In such circumstances, a suitably qualified expert may be engaged to provide an independent opinion based on their specialized knowledge, training, qualifications, and professional experience. Unlike ordinary witnesses, who are generally limited to giving evidence of facts personally observed or experienced, an expert may express opinions and draw conclusions within their recognized area of expertise. The purpose of the expert's opinion is to assist the organization in understanding complex technical matters, identifying the causes of an unsafe practice, assessing compliance with legislative or industry requirements, and determining appropriate corrective and preventive actions. Before relying upon expert opinion, the organization should be satisfied that the expert possesses the necessary qualifications, competence, experience, and independence to provide an objective assessment of the matters under investigation. The expert's opinion should be based upon sufficient facts, reliable information, recognized technical principles, applicable standards, and accepted professional methodologies. Opinions that are speculative, unsupported by evidence, or outside the expert's area of competence should not be relied upon. An expert's opinion should complement, rather than replace, the factual evidence obtained during the investigation. Documentary evidence, witness statements, inspection records, photographs, measurements, testing results, and physical exhibits should be considered together with the expert's findings to ensure that conclusions are supported by objective evidence. Where more than one expert provides an opinion, and those opinions differ, the organization should critically evaluate the qualifications, methodology, assumptions, and reasoning relied upon by each expert before determining the appropriate findings. Where necessary, an independent peer review or a second expert opinion may be obtained to resolve significant technical differences. Examples of experts who may assist in workplace investigations include mechanical and electrical engineers, structural engineers, occupational hygienists, occupational health and safety professionals, medical practitioners, ergonomists, fire investigators, environmental specialists, forensic analysts, and other competent persons possessing recognized expertise relevant to the issues under investigation. Example: an organization investigates the collapse of a lifting device used during maintenance activities. During the initial stages of the investigation, it is suggested that the collapse resulted from operator misuse of the lifting device. To determine the actual cause of the failure, a mechanical engineer is engaged to examine the failed components. Following a detailed technical assessment, the engineer concludes that the collapse resulted from metal fatigue caused by prolonged use beyond the manufacturer's recommended service life, rather than operator misuse. The engineer's conclusions are supported by laboratory testing, maintenance records, and engineering analysis. This expert opinion evidence assists the organization in identifying the true root cause of the incident, prevents incorrect attribution of responsibility, and supports the implementation of appropriate corrective and preventive measures. 4.7 Admissibility. During an internal investigation, a determination should be made regarding whether information obtained during the investigation is suitable to be accepted and relied upon as evidence. Evidence that is relevant, reliable, and sufficiently supported should be considered for inclusion in the investigation report and used to assist in determining the facts, identifying contributing factors, establishing root causes, and developing corrective and preventive actions of the unsafe practices. Not all information collected during an investigation will have the same level of evidentiary value. Some information may be excluded from reliance due to concerns regarding accuracy, reliability, relevance, consistency, or the manner in which the information was obtained. For example, information based solely on unverified statements, assumptions, or hearsay may require further validation before it can be relied upon in making investigation findings. It is important to recognize that information that is not relied upon as evidence does not necessarily mean that the information is without value. Such information may provide useful investigative leads, identify areas requiring further examination, or provide context regarding the circumstances surrounding an unsafe practice or incident. Where evidence is assessed as unreliable, insufficiently supported, or unsuitable for establishing findings, it should still be appropriately documented within the investigation records or included in an annex to the investigation report where appropriate. Maintaining a record of information considered during the investigation promotes transparency, demonstrates the integrity of the investigation process, and provides an accurate account of the matters reviewed. Investigators should clearly distinguish between evidence relied upon, information that has been assessed as sufficiently reliable and relevant to support investigation findings, and information recorded for completeness, information that was obtained or considered during the investigation, but was not relied upon due to limitations relating to reliability, relevance, or evidentiary value. The objective of assessing admissibility within a company investigation is not to exclude information unnecessarily, but to ensure that conclusions and recommendations are based on evidence that is accurate, objective, and capable of supporting sound organizational decisions in dealing with unsafe practices. 4.8 Weight of evidence. For serious or significant unsafe practices, consideration should be given to the weight that should be assigned to each piece of evidence relied upon during the investigation. The weight of evidence refers to the level of confidence and significance that can reasonably be placed upon the information in determining whether the facts under examination have been established. The assessment of evidentiary weight should consider several factors, including the credibility and consistency of witnesses, the reliability and accuracy of documents and records, the quality of physical evidence, the circumstances in which the evidence was obtained, and whether the available evidence forms a logical and consistent sequence of events supporting the investigation findings. Evidence that is supported by multiple independent sources, consistent with documented records, and capable of being objectively verified will generally carry greater weight than evidence based solely on assumptions, unverified statements, or individual recollection. The investigation team is responsible for assessing the strength, reliability, and relevance of the evidence gathered and should clearly explain the basis upon which findings and conclusions have been reached. Senior management should review the investigation findings, consider the evidence presented, and determine the appropriate organizational response, including corrective actions, preventive measures, and any necessary improvements to systems, processes, or controls. The purpose of assessing the weight of evidence is to ensure that decisions relating to unsafe practices are based on objective, balanced, and reliable information rather than assumptions, incomplete information, or unsupported conclusions. Disclaimer: the categories of evidence described herein are provided for illustrative purposes only and are not intended to constitute an exhaustive or comprehensive list of all evidence that may be available or relevant in any particular investigation. The nature, scope, and availability of evidence will vary depending on the specific facts and circumstances of each case. Thank you for watching Module 4, The Philosophy of Gathering Concrete Evidence. Having examined the principles of evidence-based investigation, we now proceed to the final chapter of this course, Module 5, Psychological Approaches to Managing at-Risk Behavior, where we will explore how behavioral principles can be applied to identify, influence, and reduce unsafe workplace practices.